Welcome to The Explainer. Today, we are diving deep into one of the most sensitive and complex areas of the justice system. We're talking about a really difficult question. When, if ever, should a person's sexual past be brought up in a sexual offense trial? You see, it's this fundamental clash between protecting a complainant's dignity and ensuring an accused person gets a fair defense. So how did the law even start to unpack this? Let's get into it.
Before we go any further, I want you to really let this quote from Lady Hale sink in, because it's the anchor for everything we're going to talk about. It just cuts right to the heart of the issue. Consent isn't some general permission slip you get based on how someone has behaved in the past. No, it's specific. It's about this act with this person right here, right now. Keep that idea in your mind, because it's the bedrock of the entire legal framework.
All right, so here's our roadmap for today. First, we're going to look at why these rules even had to be created in the first place. Then we'll dive into the super strict modern law and the intense process, this gauntlet lawyers have to go through to get this kind of evidence admitted. After that, we'll hit the central paradox of it all, the clash over what makes a trial fair. And finally, we'll see how these rules actually play out in the real world.
Okay, let's start with Section 1, why the rules exist. To really get a grip on the law we have today, you first have to understand the problem it was designed to solve. It was all about a massive shift from a culture of victim blaming to a mandate for victim protection.
For way too long, the experience for complainants in the courtroom was frankly brutal. A really important report back in 1975 found that trials would often just turn into these humiliating, intrusive fishing expeditions into their private lives. Lawyers could use totally irrelevant questions as weapons, trying to suggest that because of their past, they were less believable or, more likely to have consented this time. And the result? It felt like the complainant, not the defendant, was the one on trial.
So Parliament's first crack at fixing this, the 1976 Act, was just too weak. It gave judges this really wide discretion to allow sexual history evidence if they thought excluding it would be unfair to the defendant. In reality, that meant judges, wanting to play it safe, just approved most of the requests. The protections just weren't working. So in 1999, Parliament went back to the drawing board and came up with a much stricter approach.
So, what does a much stricter approach actually look like? Well, that brings us right to Section 2, the 1999 Act's strict rules. You can think of this as Parliament trying to build a solid protective wall around the complainant in court.
First thing we need to get our heads around is what the law even means by sexual behavior. And let me tell you, it's incredibly broad. We're not just talking about previous relationships. It covers any sexual conduct at all, even stuff you do on your own, like watching porn. In one case, it even included someone's sexually themed quiz answers on social media. This wide definition is completely intentional. It's meant to stop any sneaky, backdoor attempts to smear a complainant's character.
And that wide definition leads us to the absolute core of the law, Section 41 of the 1999 Act. It lays down a really powerful, really clear default rule: total exclusion. The starting point is a flat-out no. Defense lawyers are banned from asking about a complainant's sexual past unless the judge gives them explicit permission. And as we're about to see, getting that permission is designed to be really hard. Okay, so on to Section 3, the admissibility gauntlet. If the default position is no, if that door is slammed shut, how does any of this evidence ever get into a courtroom? Well, it has to survive this incredibly tough multi-stage challenge, what lawyers call a legal gauntlet.
Let's walk through this gauntlet step by step. It all starts with a private application from the defense team, where they have to lay out their exact reasons. Next up, the category check. Does the evidence fit into one of a few tiny, narrow exceptions? We're talking about things that happened at the exact same time as the alleged offense, or something so strikingly similar that it just can't be a coincidence. Even if it passes that, it faces a credibility check. Is this really just a thinly veiled attack on the complainant's character? If so, blocked. And finally, there's the big one, the safety test. Would keeping this evidence out create a real risk of an unsafe conviction, of an innocent person going to jail? Only if it clears every single one of those hurdles can a judge even think about granting permission.
A really great way to think about this is like a super strict security checkpoint at an airport. The defense wants to bring a piece of luggage, the sexual history evidence, into the courtroom. The judge is the security officer. Their job is to scan it, check it against a very short list of approved items, and figure out its true purpose. And the whole system is set up so that most of that luggage, because it's considered irrelevant and damaging, is never allowed through that gate.
So the system is designed to be really protective. But what happens when that protection seems to crash into another core principle of justice? And that brings us to Section 4, the fair trial paradox.
This is where the whole system gets put to the test, and where two fundamental rights collide head-on.
And here it is, the million-dollar question. What happens when these incredibly strict protective rules go so far that they might actually stop a defendant from being able to put forward their side of the story? What if, in a really rare and specific case, the complainant's past actually is relevant to figuring out what happened?
Well, this exact question just exploded in this landmark case called RVA back in 2001. The defense wanted to bring up evidence of a prior consensual sexual relationship with the complainant, arguing it was relevant, but the strict rules of Section 41 said, nope, you can't. The case went all the way to the top court, the House of Lords, and they made a huge ruling. They said that the rules protecting the complainant cannot completely steamroll the defendant's fundamental right to a fair trial. The bottom line was, if excluding a specific piece of evidence would lead to a real injustice, the judge has to find a way to let it in.
So, how has that played out in practice? Well, it's definitely not a free-for-all. You can see the courts being really careful. In a case called Mukadi, some evidence was allowed in, but only because it directly contradicted a very specific claim the complainant had made. But then in White, the court said that a complainant's past work as a prostitute was totally irrelevant to whether she consented on this particular occasion. And Hamadi just confirmed that someone's sexual history with a completely different person is almost never going to be relevant. So the courts are clearly weighing the unique facts of every single case.
So these cases show a system that's really trying to find its balance. But that brings us to our final section, the law and practice. Because even with all these rules and landmark cases, the system on the ground is, well, far from perfect.
When you talk to lawyers and people working in the system, they point to some major challenges. For one, there's still a lack of clarity. Different courts can define sexual behavior in different ways. There are also clever loopholes that can be exploited, like shifting the argument away from whether the complainant consented and onto the defendant's belief in consent, which can be a backdoor way to bring in forbidden evidence. Throw in last-minute applications and the fact that different judges can interpret the same rules differently, and you end up with a system that can feel really unpredictable.
And this leaves us right back where we started, with the final dilemma. It's the question that's been at the core of this whole explainer, and it's one that the justice system grapples with every single day. In the absolutely vital mission to protect a complainant from shame and prejudice, how do we guarantee that we never, ever compromise the fundamental right of an accused person to a fair trial? There's just no easy answer to that.